Hello, and welcome to the International Business and Law Academy. My name is Ann, and today we will be discussing a new topic of competition law. The subject of focus today is the territorial principle, and we will be investigating the case of McClinchy versus Shell Chemical Co. in order to apply the subject. The very foundation of competition law lies along with the territorial principle. The principle itself dictates the rightful or wrongful application of competition in accordance to nations. So let's jump into the case. Facts. Dande Products, owned and operated by McClinchy, contracted with Shell Chemical. The agreement established Dande as Shell's exclusive representative for the promotion and solicitation of orders for BP pipe resins throughout Southeast Asia. In 1982, Shell notified Dande that these various contracts would be terminated. McClinchy and Dande brought suit against Shell under Sections 1 and 2 of the Sherman Act, claiming Shell's refusal to deal injured Dande's Southeast Asian operations. Shell moved to dismiss the suit on the grounds that the U.S. court did not have jurisdiction to hear the antitrust claim. So the issue to think about is, do the U.S. courts have jurisdiction to hear this antitrust claim? Ms. Chi, start us off.
I think Mr. Clinton has Dundee isn't able to show any true element of anti-competitiveness and antitrust injury to competitions. With the termination of their contract, there was not only injury to their own business.
Yeah, can you elaborate?
I agree with Ms. Chi. Because antitrust laws were enacted for the protection of the competition, not the competitor. And on top of that, there was only eliminations of one single competitor, which is Dande, and without any cooperative actions from other businesses, it does not prove an anti-competitive effect.
That is true. Ruby?
There's another problem with Dande's claim where they stated that the termination of contracts have caused injury towards the customers or potential customers in Southeast Asia. But this questions the validity of using U.S. trust law to address such foreign commerce.
That is perfect. Let's carry on with the subject within territorial principle. Mr. Ho.
Because the settlement as reaches only conduct that has a direct, substantial, and reasonable foreseeable effects on the U.S. domestic market, import, commercial, and U.S. export trade, then they claim a permitted.
Yes. Torin?
This is true. Why this exempt from the U.S. Antitrust law conduct? Because it is lacks such a domestic effect even when the conduct is originated in the U.S. or involved in the U.S. owned or involved the U.S. owned entities operating abroad, making Dande's claim only relating to foreign commerce.
Thank you all so much for your wonderful ideas. You all talked about points within competition law and specifically the territorial principle. But before we get into the official decision of the case study, let's review the relevant topics regarding this case. So, what is the territorial principle? Mr. Ho, can you start us off?
Yeah. International law generally recognize the rights of nations to exercise jurisdiction over person and property within its national border under concept known as the territorial principle.
Can you tell us more, please?
Okay, so the territorial principle is still significant as compared to the past. The U.S. expressed intention to extend its antitrust jurisdictions to punish foreign firms that injures the U.S. overseas exports. Since the U.S. intentions were condemned by much of the world, the territorial principle was implemented.
I would like to add to Kan that hence this extension of antitrust enforcement is out of step with the jurisdiction reached that most other nations grant to their own antitrust law. For instance, the European Community generally limits its antitrust powers to conduct by undertakings within the European community that affect intra-community trade.
But there must be some shortcomings to the territorial principle. Tran, please.
Though it is important to highlight the shortcoming of the Territorial principle, first is the sovereign immunity limitation. The Foreign Sovereignty Immunities Act of 1976 provides that the government action of foreign sovereign and their agent are exempt from antitrust liability, meaning that the commercial activities of the sovereign are not included within the sovereign immunity doctrine.
Yep, that is definitely a shortcoming. There's a second one, Ms. Chi.
Yeah, I think the second limitation is the Archer State Doctrine. The Archer State Doctrine provides that U.S. courts should not adjudicate a politically sensitive dispute that would require the court to determine the legality of sovereign as by foreign nation. Under the antitrust enforcement guidelines, the U.S. Department of Justice will not pursue the antitrust action involving foreign jurisdiction.
Thank you all so much for your discussion. You guys are truly knowledgeable about this topic. Now let's return to the case, and the decision will be no. McClinchy and Dande have failed to show the requisite antitrust injury to competition. The antitrust laws were enacted for the protection of competition, not competitors. The elimination of a single competitor without more does not prove anti-competitive effect. Hence, other than establishing injury to itself, Dande has only claimed injury to customers or potential customers in Southeast Asia. The Foreign Trade Antitrust Improvements Act make clear that the Sherman Act reaches conduct that has a direct, substantial, and reasonably foreseeable effect on U.S. domestic import commerce or U.S. export trade. Thus, it exempts from U.S. antitrust law conduct that lacks such domestic effects, even where the conduct originates in the U.S. or involves U.S.-owned entities operating abroad. Dande's claim relates only to foreign commerce without the requisite domestic anti-competitive effect. Thank you so much to the International Business and Law Academy for supporting me in the research program for competition law. And now I would like to introduce Professor Son.
Thank you. Thank you for your presentation, the handsome man. Your presentation today, you talk about the topic territorial principle. That means when the competition law includes the antitrust and monopoly, they always get different nation and different law like sovereign immunity,
Yes.
and also that make difficult for you for your presentation. But you are very good, and thank you for your dedication. Okay.
Thank you.
Thank you.